Thanks a lot. So according to the program, I'm TBA, so I guess I'm a surprise. What I was asked to talk about is to talk about the conflict of jurisdiction. So I added now as a subheadline, listening to you guys before, who governs where all of this is running on. We probably just absolutely a cut to everything you've talked about before. You probably remember the Snowden slides, this kind of good upstream down, prism surveillance idea of all of these cloud systems actually being connected to the NSA, which was rather interesting because at the time we also had a better idea of how all of this is working. There's different steps of this whole process. We knew which companies are connected to it. We looked into Facebook, but by now any kind of Microsoft, AWS and so on are usually connected to them as well. They also have the reports that they provide all that data to the NSA. All of that happens under a law in the US that's called Fisa 702. And it's extremely interesting because other than normal surveillance laws we know, it requires only two things in a very simplified version. But it requires basically an electronic communication service provider. So that's your Amazon cloud, your Microsoft cloud, whatever it is. And it requires what they call foreign intelligence information, which is an extremely broad word and definition. So anything that is relevant for the foreign conduct of the United States, which means anything we're interested in. And it depends on what industry you're in or what you're doing. We usually deal with personalized data, so we fall under the GDPR and have to look into that. But a lot of that is really interesting also for espionage reasons, if there's certain data that is just really relevant for international relationships. Typical one that I was talking to was like a big oil company was like, I'm not going to put anything in there because we all know that everybody's interested where the next oil field is up. And that is all in this definition of foreign intelligence information. What's interesting in this US system is that there is no individualized judicial decision. So usually you have some criminal that you want to go after, someone that is under suspicion, you need a probable cause, you need a judge to review that. The US doesn't do that. It has a certification for 1 year. So basically there's a FISA court that allows the whole surveillance system for a year without talking about individual access. The individual access is done by an operator. There is so-called minimization and targeting procedures to filter out American citizens and American permanent residents, so US persons. Because all of that would be a violation of the Fourth Amendment in the US, so you couldn't do that on US citizens, but because foreigners don't have any fundamental rights in the US because it's citizens' rights and not human rights, you filter them out and you are fair game and you can go ahead. And all of that is then basically done with a directive to the service provider, and they have to provide something like an API. The API is not defined in law, the rest is in the law, but it says that they have to aid the acquisition of the data. So basically these companies are by law compelled to make that data available in whatever format possible. We looked at that from a European side, and in the EU, at least for personal data, we have the GDPR. And the GDPR requires that you're not allowed to send data abroad by default. So the default in Europe since 1995 is you're not allowed to send personal data into anything that's outside of the European Union or the European Economic Area, to be precise. With a couple of exemptions, if there's really necessary data transfers and they're not structural, but usually we talk about outsourcing where just the whole thing goes into the cloud and it's somewhere. And there we have some systems to expand European law that a lot of these systems run on. So from a legal side, usually there's adequacy or standard contractual clauses right now that are used. And that's a system that would work if you have a recipient in the US, some company over there that receives your data, be it one of the big cloud providers or someone else. And usually there's the possibility to basically contract into European law. So you have some American company that says, okay, I sign a paper here that I follow the GDPR. And that's all great if there's no data protection law in another country. Like in the US, there's no Data Protection Act, no general one, so you can fill that vacuum with a contract. The big problem is that in the US, in addition to that vacuum, you also have the surveillance law. So on a very high level, right now have a problem that the EU requires privacy and the US requires surveillance from the same operator. And that is where you have a very high level conflict of jurisdiction. If you take anything from this presentation, take this slide, because that problem is going to be recurring for the next 10 or 20 years probably. And I also want to kind of put a little asterisk on that. I talk about privacy, but the issue we're having is probably much broader than privacy. We start to regulate the internet more and more, and each country does that. And unless you have unified worldwide laws, or at least among democratic countries, certain standards, you would have more and more of these conflict of jurisdictions. Talk about freedom of speech, for example, in Austria, my home country, Holocaust denial is a crime. In the US, that's freedom of speech. What governs that cloud now? And all of that is right now still a big issue. We litigated that in these so-called Schrems litigations. Unfortunately, they now have my second name, so half of the privacy industry now has a personal enemy. But basically, the litigation went like that. We went on Facebook in Ireland. We went to the Irish data protection regulator at the time. That was that guy in the small office in Port Arlington, which is a small town with like 5,000 inhabitants, and they were there to regulate Google and Facebook, and which didn't go that well. They basically told us to fuck off and said that our complaints are frivolous and vexatious and shouldn't really be heard. But it went all the way to the Court of Justice, which is the highest court of the European Union. And usually they do a proportionality test. So they usually say, is an interference with your right to privacy proportionate or not? And that's a whole balancing exercise that they do. But in this case, they didn't go that far. They basically just say, we didn't need to do a proportionality test because what the US does is so extreme that it's, for us, a violation of the essence of your fundamental right, which is the first time the Court of Justice has ever found that. So they said, what's happening here is so crazy, we don't even have to check if that's proportionate anymore. It's out of the door right away, which was surprising. We didn't think that they will go that far. But it kind of gives you an idea of how much there is a conflict in the background with a lot of the legal stuff on all of that. There are a couple of other findings that I'm just going to quickly jump. But basically what we're in the world of right now is that if you at least deal with personal data, you on the one hand have to comply with the GDPR, and if your data goes abroad, it has to be what they call essentially equivalent, the protection of the data abroad. In addition to that, you, however, also have to an assessment of this other country on a fundamental rights level. So and the interesting thing is the requirement is that the company has to do that. So whoever sends that data abroad or uses a cloud service has to do that assessment now. And that was actually lobbied for by the industry. They wanted to have what they call self-regulation. Now when people have to self-regulate, there's a lot of crying about that as well. So the solution on the European level was to do a so-called adequacy decision. So what the European Commission can do is that they can assess a whole country on behalf of the companies, so that not everybody has to do that individually. And after the first adequacy decision, which was our first litigation, was killed, the safe harbor at the time, they came up with a new one called Privacy Shield. And what politics did is that they basically just took the old text that was invalidated by the courts, put this wonderful new logo on top of it, and pass the same text again. That's how you fix issues if you're in politics sometimes. Just a couple of quotes from that. There was, for example, a press release where they said the US authorities assured that there's no indiscriminate or mass surveillance by national security authorities. So basically what the European Union did is that they just said, the US said they don't do that, so it's fine. And I can go into that for a second, but if you just real quick, there's even in the annexes of the decision, it says that there's mass surveillance, it talks about bulk surveillance, and then there's wonderful footnotes. And if you go into the footnote of bulk, it says that bulk is actually only bulk in certain times, but most of the times bulk is not bulk. So it basically just uses these words interchangeably and not in any kind of meaning that a normal person would ever use. And what the European Commission did is that they basically didn't assess US law, but they basically had all of this US law combined in a letter by the US authorities. And the US authorities explained American law and basically said it's all fine and good. And then the EU annexed this letter to their decision. So they didn't review the law itself, but they reviewed the American review of their own law. So it's a bit like asking the Chinese government for their human rights assessment, and then the Chinese government comes around and says, we have a great human rights record, and then you attach that to a decision and be like, oh, we're good, the Chinese are great. And that's basically what the European Union did here. There was even a system with like an ombudsperson that was a replacement for what the Court of Justice required. They required that there's a court in the US where you, as a concerned citizen, can go to. And they came up with an ombudsperson. And that ombudsperson you could not directly go to, but through a data protection authority and so on. It was rather complicated. But the interesting thing is you would always get the same answer back. No matter what your case is, you would always get the answer back that your case has been investigated, and the US either complied or remedied the situation. But they don't tell you if there was a breach of the law that they now remedied or there was no breach originally. Plus, they will not confirm that you were even under surveillance. So they basically will give you a rubber stamp answer no matter what. And they tried to sell that to the Court of Justice the second time around as a court. We called it lipstick on a pig at the time. The Court of Justice agreed. There was basically this Schrems 2 litigation that was rather complicated. We had more than 4,000, it's about 10 million euros in costs to litigate stuff like that, just to give you an idea. But basically the core arguments there were that Facebook said that there's no surveillance law that goes beyond the EU. So they basically, a lot of the industry, or a lot of what the industry people are trying to argue is, oh, there's one or two bad apples in the European Union as well. So if the US is just as bad as they are, we're all good. That's just not how it works. You basically have a different assessment though. We made the argument that you have to actually do this case-by-case analysis, and that the data protection authorities can stop the data transfers. And the Irish DPC had a very extreme view that all of this should be invalidated, which went way too far. The outcome was that basically the Court of Justice followed us and joined our view there. And there's now the option that each data protection authority can actually stop these data transfers in individual cases. And they started doing that in the last couple of months. So for example, we had the first decision in France, in Austria, and by the European Data Protection Board, which govern the European Data Protection Supervisor, which governs the EU institutions. Probably for you guys more interesting is kind of the practical consequences. What does all of this mean if you actually process personal data? If you actually have data that needs to go abroad, for example, if I book a hotel in North Korea, I can still do that. If I really want to be in Pyongyang, that booking is really necessary to go there, otherwise I don't have a hotel room. But for the whole outsourcing part, we actually have a major problem. If you do not process personal data, you're good. You're outside of the GDPR, so a lot of the stuff that is done is not necessarily personal data. There are these situations of what I just called kind of necessary transfer. So if you actually have to book a hotel or a flight or something like that, that's all good as well. But if you outsource your processing to one of these electronic communication service providers, you actually have a major problem if personal data is involved. That also covers if that outsourcing is done to a server in the EU. I mean, I don't have to tell probably this room that servers don't really give a fuck which geography they're standing in, but a lot of lawyers still need that information. And basically these surveillance laws in the US do not just cover servers in the US, but they cover anything where there is technical access to that server. So you basically can separate it technically to say, the server is actually managed by some other company where you don't have any access from the US, but as long as there is what they call possession, custody, or control, US companies are obliged to actually hand all of that out, including any kind of keys, any kind of encryption stuff that they have. So they basically have to hand it all over. There is the possibility that you transfer data to a recipient in the US that is not a Fisa company, so just a normal company. Typical example is if an airline sends something to their booking office there, that booking office is not an electronic communication service provider and could probably be outside of the scope of these US surveillance laws. One thing real quick, at the end, there was this talk about so-called supplementary measures. So the industry said, okay, the law is terrible, we're gonna try to find some other solution. And there's basically technical options that can work in certain situations, and contractual options that, at least for the US, usually don't work, because in the US, these contractual options are usually overridden by the law. The law says you're not allowed to talk about it, you're not allowed to stop it, you're not allowed to do anything as a company. You have to even not allow your CEO to know that that happens within your own company. So there is not really much option from a legal perspective to do something, but from a technical side. There is basically these solutions that now the industry has put forward. A lot of that is just total bullshit. We had, for example, the one from Microsoft. They added that you would actually get, for example, compensation if your data is violated or your data rights are violated, which is already under the law in the GDPR anyway. So they basically just restate the law and say that's now fixing the problem, which doesn't. Facebook, for example, just said that they still view that the Court of Justice is simply wrong. So their submissions right now in our legal cases is just, we are right, the Court of Justice is wrong, so therefore there's no need to fix anything. A wonderful one was Google. They basically said their supplementary measures is things like putting fences around their data center and having a sign saying do not enter. And that apparently now should deter the NSA. And all of that we have in ongoing litigation. I just mentioned before, that's the DPAs that have already decided, but right now there is a group of DPAs in the background, data protection authorities, that have a task force that basically make these decisions right now, and they will come up and will probably be an issue for the next time to come. Last two slides or last two topics. The big question is usually what is a proper solution. I'm not a big fan of kind of bringing this problem up and over again, but it needs to be talked about. I guess the proper solution would be a common level of protection. That's what they usually call a no-spy agreement. That at least kind of the democratic countries would go together and say, okay, we all have the same rules for access to data. There needs to be a judge. There needs to be probable cause. These basic things that we all have nationally, anyways. But we would have to grant these rights to people from another country as well. Even in the EU, that's a problem right now. So if I'm an Austrian and most of my data is trafficked through Frankfurt, I don't have any place to go in Germany to kind of claim my rights. And that is a fundamental problem we have right now with a lot of the surveillance, because the surveillance is still thinking extremely nationally, but we have a globalized internet, and there you have that conflict. In relation to the US, the big answer you usually get, or the big problem, is no way you're ever going to pass anything like that in US Congress, because we can't even pass our budget, so how the fuck should we pass surveillance reform? Which is kind of the realistic answer on a lot of that right now in relationship to the US. Knowing that, they just announced last Friday that there should be a new EU-US framework. It's an announcement by von der Leyen, the head of the European Commission, and Joe Biden. The interesting thing is, so far there's only headlines, so even the people that negotiated stuff, I don't think really know how that should work in reality, but politics decided we're just gonna do that another time around. And what they'll try to do is an executive order that basically tries to introduce some of the EU elements in US law. The problem is that that doesn't have necessarily binding effect in the US, so it's more of a paper tiger again. A wonderful one is that they're going to start what they call data protection court in the US, but it turned out already that this court is actually an executive body, so they just put the name court on something that is not a court to make it look like a court. So that's right now the options of trying to fix it. And there's huge issues also on what companies can do with the data once it's transferred under the current instruments, but that goes beyond the time that's allocated here. I hope that was like from some totally different world maybe, or somehow interesting for you guys. I think we have 1 minute for questions, if there's at least one.
Anyone, some questions for Max? Whirlwind. Your chance to influence Schrems 3.
Did anybody of you have to deal with that stuff already? Yep.
So yeah, there are a lot of GDPR issues when you process resumes from people. So we have to sign a lot of GDPR agreements, and we also say our cloud providers, they have to be ISO 27701 certified in order to process this type of data. So it's a very hot topic.
Okay.
For us.
Anybody else?
Can you comment on the privacy for data that is not structured, like text messages, emails, anything that doesn't explicitly say this will contain like something personal?
Yeah, generally the GDPR applies to anything that's personal data, so it doesn't matter if you know that it's personal data or not. If you really don't know, there are cases where, for example, we had someone on our website, because as a privacy NGO, they try to fuck you with privacy. So one person just entered into the search file all his like email addresses in the search box, then arguing that that could be in our server logs and therefore there's personal data in our server logs, and we're like, seriously? And for that stuff, you can usually, at least on the penalty level, you would not have any kind of personal guilt because you couldn't have probably expected that. But generally, if you process any data where you kind of know that there is some personal data in it, you usually, in practical terms, have to treat it as it. Otherwise, you have to separate and say, okay, these 5 fields, no, this, yes. It's oftentimes then easier to just cover the whole thing and say, okay, that's expected to be personal data. The more it's messy data, the more that gets really complicated. The more it's not really structured data where you can say, okay, that's an HR file, that's personal data, and that is, I don't know, weather data that is not personal data. The more that gets interconnected, the harder it is. The law doesn't foresee a privilege or something for mixed data. It just says your problem. It's probably not the most useful answer, but at least an honest one.
Good. You're also speaking at the Microsoft session, right? Are you? You have to still? Okay, but that's the plan.
Okay.
Okay. Scarlett said that would be the case. Okay. Good. I think we have to move on. Thank you very much, Max.